hello, everybody. Welcome to Night Court. Hey, it's fun. Good to see ya. I'm really glad that you're here with me tonight. It's been a crazy week. We're only halfway through. Oh, we're halfway there. But did you do it? Don't lie. Don't lie. I'm sitting here. It looks like 1, 2, 3, 4 of you got your answers in, and so I've got 4 more to grade to look at before we kind of talk about trivia. But we got a lot going on tonight. A lot. If you saw any of my posts, you'll know that here's the order. And did I see my own post? That's the good question. That's the question. Um, all right, so here's kind of the order. I'm going to say hello to everybody. See how y'all are doing. We're going to do an introduction to Joel Guy Jr. tonight, and that is going to come in the way of reading a document that basically includes everything that was found up and so it's a lot of stuff, a lot of stuff. And then we are going to go over the trivia answers, update the leaderboard, and relax with a guided meditation. And I think it's okay to do it at this point because then we're going to hop into closings of Jodi, because at this point I'm just going to I'm tossing out the other witnesses. I don't think we're going to see anything that's going to change our minds. But yes. So, you don't have to drop out of trivia. You can do it when you want. You definitely don't have to make it every single week. But that's why I like to have like almost a full week of you can answer questions. So you don't have to do it that day. Okay, so guided meditation. What is that going to be about tonight? It's going to be about finding yourself. Why? Because it's in memoriam of the convict who apparently just couldn't do so for 13 days. 14, somewhere in there. So we're gonna do finding yourself. And then we're gonna continue, like I said, by skipping along to the closing arguments of Jodi and push on through there. So, because I think after trivia, after Joel, we're all gonna need a second. We all gonna need a second. I really don't know when I'm going to grade those. I might actually have to shift some things around here so I can grade them. If you don't want to find yourself, I wish I had a witty retort. I don't have a witty retort. If you don't want to find yourself, get lost. That sounds mean. I don't like that. I don't like that response at all. Hello. Let's see. I don't believe you. Thank you for hanging out. Thank you for the awesome shirt comment. Yes. Oh, living on a prayer. Good evening. I hope everybody's doing well. Brandi did wonderfully today. I don't know if you guys have heard the podcast, the newest episode on conspiracy in Canton, but holy cow. I listened to it its entirety today, and I told Brandi that it is one of the most professionally put together things. I'm so excited for her and for the channel. And that podcast within just, I guess, almost 48 hours has 800 plus downloads, and that pushed us over 10,000. So our podcast now is sitting at over 10,000 downloads, and I think 10,100, which is awesome. Nope, there's no second one yet. No second one yet, just the first one. But that one the first one already had me ready to go for the second one. So, yeah, today was crazy. Today was definitely a hump day. It made me work for the fact that I was here tonight for sure. Thank you very much. Thank you. Hello, Ricky. Howdy. Nope. Can't. Nope. Put me in North Carolina for a couple of days, and I'll be able to do a convincing howdy. For sure. Hopefully y'all's week has been going well. One day at a time, right? One day at a time. And let's get into our first 5, shall we? I think we shall. All right. Do do do. Depending. Nope, don't like that. Don't like that one bit. That's a little better. Okay. I just need to move my chair. And top 5. Top 5. Pillows. Sorry, I had I had some mixed messaging. Wendy, I'm so sorry. That's quite some. That's a long time. That's a long time. Oh goodness. I don't know. I don't know whether to laugh or cry for you. I'll do a little bit of both. For sure. Yes, please. You put me around my buddy Gabe, who's born and bred in Reidsville, North Carolina, and I'll pick it up. He is a dude who, when he says folk, like those are crazy folk, I believe it. I believe it for sure. Yes, congrats to the top 5. It was that doggone manhunt. I think that took some years off of everybody's lives, except for me, because I watched it when we did, and that was it. But I'm so glad that he's been caught. We can move on with our lives. We found Waldo. We found Waldo. So, yeah. All right. Hi, Terry. Everybody, I owe Terry so many different things. I'm so behind. So behind. All right. So we're gonna need to make a. I'm gonna need to do a quick switch of a couple of things. I know what I said we were gonna do, and now I'm gonna have to flip it because I still have a couple of quizzes to grade. So, what I want to do is before we hop into the case of Joel Guy Jr., we're going to start watching the closing arguments. I don't know if we're going to finish prosecution's closing arguments tonight, but that's okay. Juan likes to talk, so um, we're going to start that. And when I'm done with the quiz stuff, we'll then move back into our order because I want to make sure that I have an accurate. Want to make sure I have an accurate scoreboard for you. I also want to make sure that I have the ability to edit it. Okay. So, provided you all are flexible with me, I can be flexible with you. So let's get started on the whole Jodi thing. Okay. That's a really odd shape for me, I think. All right.
Please be seated. The record will show the presence of the jury, the defendant, and all counsel. All right, ladies and gentlemen, the bailiff will give each of you a copy of the final instructions. The copy you receive is your copy. Feel free to make any notes you would like on your copy. Your copy will be shredded at the end of the trial. After each of you receive a copy, I'm going to read these instructions to you. Looks like we need one more copy for juror number 2. Does everyone have a copy? Page 2. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened.
Jury instructions.
Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. In their opening statements and closing arguments, the lawyers have talked to you about the law and the evidence. What the lawyers said is not evidence, but it may help you to understand the law and the evidence. During the trial, the lawyers are permitted to stipulate that certain evidence exists. This means both sides agree the evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. You are to treat a stipulation as any other evidence. You are free to accept it or reject it in whole or in part, just as any other evidence. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility she is not guilty, you must give her the benefit of the doubt and find her not guilty. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. You must decide whether the defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant acting with the advice of an attorney. The defendant's decision not to produce any evidence is not evidence of guilt. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial, excuse me, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. The state has charged the defendant with certain crimes. A charge is not evidence against the defendant. You must not think that the defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may infer or find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence, regardless of whether it is direct or circumstantial. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Evidence of other acts has been presented. You may consider these acts only if you find the state has proved by clear and convincing evidence that the defendant committed these acts. You may only consider these acts to establish the defendant's motive, intent, preparation, or plan. You must not consider these acts to determine the defendant's character or character trait, or to determine that the defendant acted in conformity with the defendant's character or character trait and therefore committed the charged offense. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. You must evaluate the defendant's testimony the same as any witness's testimony. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. Count 1 charges the defendant with first-degree murder. Arizona law recognizes two types of first-degree murder: premeditated murder and felony murder. The state has charged the defendant with both types. The crime of first-degree premeditated murder requires the state to prove the following. Number 1, the defendant caused the death of another person, and 2, the defendant intended or knew that she would cause the death of another person, and 3, the defendant acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. While reflection is required for first-degree murder, the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The crime of first-degree premeditated murder includes the lesser offense of second-degree murder. You may consider a lesser offense if either 1, you find the defendant not guilty of first-degree premeditated murder, or 2, after full and careful consideration of the facts, you cannot agree on whether to find the defendant guilty or not guilty of first-degree premeditated murder. You cannot find the defendant guilty of any offense unless you find the state has proved each element of that offense beyond a reasonable doubt. The crime of second-degree murder requires proof of one of the following. 1, the defendant intentionally caused the death of another person, or 2, the defendant caused the death of another person by conduct which the defendant knew would cause death or serious physical injury, or 3, under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of another person. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. The difference between first-degree murder and second-degree murder is that second-degree murder does not require premeditation by the defendant. If you determine that the defendant is guilty of either first-degree murder or second-degree murder, and you have a reasonable doubt as to which it was, you must find the defendant guilty of second-degree murder. If and only if you find the elements of second-degree murder were proven beyond a reasonable doubt, you must then consider whether the homicide was committed upon a sudden quarrel or heat of passion resulting from adequate provocation by the victim. Adequate provocation means conduct or circumstances sufficient to deprive a reasonable person of self-control. Words alone are not adequate provocation to justify reducing an intentional killing to manslaughter. There must not have been a cooling off period between the provocation and the killing. A cooling off period is the time it would take a reasonable person to regain self-control under the circumstances. If, after finding the elements of second-degree murder were proven beyond a reasonable doubt, you also unanimously find beyond a reasonable doubt that the homicide was not committed upon a sudden quarrel or heat of passion resulting from adequate provocation by the victim, then you must find the defendant guilty of second-degree murder. If, after finding the elements of second-degree murder were proven beyond a reasonable doubt, you also unanimously find beyond a reasonable doubt that the homicide was committed upon a sudden quarrel or heat of passion resulting from adequate provocation by the victim, then you must find the defendant not guilty of second-degree murder, but guilty of manslaughter. If you determine that the defendant is guilty of either second-degree murder or manslaughter, but you have a reasonable doubt as to which it was, you must find the defendant guilty of manslaughter. The defendant cannot be guilty of both second-degree murder and manslaughter. As stated earlier, count 1 also charges the defendant with first-degree felony murder. The crime of first-degree felony murder requires the state to prove the following 2 things. 1, the defendant committed or attempted to commit burglary in the second degree, and 2, in the course of and in furtherance of committing burglary in the second degree or immediate flight from it, the defendant caused the death of any person. An attempt requires the state to prove that the defendant intentionally did something which, under the circumstances she believed them to be, was a step in a course of conduct planned to culminate in the commission of the offense. The crime of burglary in the second degree requires proof that the defendant, 1, entered or remained unlawfully in or on a residential structure, and 2, did so with intent to commit any theft or felony therein. Residential structure means any structure, movable or immovable, permanent or temporary, that is adapted for both human residence and lodging, whether occupied or not. Intentionally or with intent to means with respect to a result or to conduct described by a statute defining an offense, that a person's objective is to cause that result or to engage in that conduct. There are no lesser included offenses for first-degree felony murder. In order to find the defendant guilty of count 1, it is not necessary that you be unanimous with respect to whether the defendant is guilty of first-degree premeditated murder or first-degree felony murder. The only requirement is that you be unanimous that the defendant is guilty of first-degree murder, which can be either first-degree premeditated murder or first-degree felony murder. If you find the defendant guilty of first-degree murder, you must indicate on the verdict form how many of you have found the defendant guilty of first-degree premeditated murder and or first-degree felony murder. By way of example only, the jury can be unanimous as to both theories or just one theory, or it may be divided. A defendant is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent, attempted, or threatened use of unlawful deadly physical force. And 2, the defendant used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in self-defense only to protect against another's use or apparent, attempted, or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use or threatened use of unlawful deadly physical force. You must measure the defendant's belief against what a reasonable person in the situation would have believed. A defendant has no duty to retreat before threatening or using deadly physical force in self-defense if the defendant, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in an unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification.
Okay.
If the state fails to carry this burden, then you must find the defendant not guilty of the charge. If there have been past acts of domestic violence against the defendant by the victim, the state of mind of a reasonable person shall be determined from the perspective of a reasonable person who has been a victim of those past acts of domestic violence.
All of
Domestic violence means any act that is an offense, including assault, aggravated assault, threatening and intimidating, endangerment, sexual assault, or unlawful imprisonment, committed while the victim and perpetrator are in a romantic or sexual relationship. The following factors may be considered in determining whether the relationship between the victim and the perpetrator was or had been a romantic or sexual relationship.
These are the jury instructions. They have not done closings yet.
A, the type of relationship. B, the length of the relationship. C, the frequency of the interaction between the victim and perpetrator. D, if the relationship has terminated, the length of time since the termination. Definitions. Intentionally, intent, or intended means that a defendant's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knew or knowingly means that a defendant acted with awareness of or belief in the existence of conduct or circumstances constituting an offense. It does not mean that a defendant must have known that the conduct is forbidden by law. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. Recklessly or reckless disregard means that a defendant is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be such that disregarding it is a gross deviation from what a reasonable person would do in the situation. A person who creates such a risk but is unaware of such risk solely by reason of voluntary intoxication also acts recklessly with respect to such risk. Physical injury means the impairment of physical condition. Serious physical injury includes physical injury which creates a reasonable risk of death or which causes serious and permanent disfigurement, serious impairment of health, or loss or protracted impairment of the function of any bodily organ or limb. Firearm means any loaded or unloaded handgun, pistol, revolver, rifle, shotgun, or other weapon that will expel, is designed to expel, or may readily be converted to expel a projectile by the action of an explosive. Firearm does not include a firearm in permanently inoperable condition. Physical force means force used upon or directed toward the body of another person and includes confinement, but does not include deadly physical force. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law or, where the context so requires, not permitted by law. Endangerment. The crime of endangerment requires proof of the following. 1, the defendant disregarded a substantial risk that his or her conduct would cause physical injury, and 2, the defendant's conduct did in fact create a substantial risk of physical injury. Threatening or intimidating. The crime of threatening or intimidating requires proof that the defendant threatened or intimidated by word or conduct, 1, to cause physical injury to another person, or 2, to cause serious damage to the property of another person. Assault. The crime of assault requires the proof that the defendant, 1, intentionally, knowingly, or recklessly caused a physical injury to another person, or 2, intentionally put another person in reasonable apprehension of immediate physical injury, or 3, knowingly touched another person with the intent to injure, insult, or provoke that person. Aggravated assault. The crime of aggravated assault requires proof of the following. 1, the defendant committed an assault, and 2, the assault was aggravated when the defendant caused serious physical injury to another person. The crime of unlawful imprisonment requires proof that the defendant knowingly restrained another person. Restrain means to restrict a person's movements without consent, without legal authority, and in a manner that interferes substantially with such person's liberty by either moving such person from one place to another or by confining such person. Restraint is without consent if it is accomplished by physical force, intimidation, or deception. Sexual assault. The crime of sexual assault requires proof that the defendant, 1, intentionally or knowingly engaged in sexual intercourse or oral sexual contact with another person, and 2, engaged in the act without the consent of the other person, and 3, the defendant knew the act was without the consent of the other person. Oral sexual contact means oral contact with the penis, vulva, or anus. Sexual contact means any direct or indirect touching, fondling, or manipulating of any parts of the genitals, anus, or female breast by any part of the body or by any object or causing a person to engage in such contact. Sexual intercourse means penetration into the penis, vulva, or anus by any part of the body or by any object or masturbatory contact with the penis or vulva. Without consent includes any of the following. 1, the victim is coerced by the immediate use or threatened use of force against a person or property. 2, the victim is incapable of consent by reason of mental disorder, mental defect, drugs, alcohol, sleep, or any other similar impairment of cognition, and such condition is known or should have reasonably been known to the defendant. Mental defect means the victim is unable to comprehend the distinctively sexual nature of the conduct or is incapable of understanding or exercising the right to refuse to engage in the conduct with another. 3, the victim is intentionally deceived as to the nature of the act. 4, the victim is intentionally deceived to erroneously believe that the person is the victim's spouse. Any notes you may have taken during the trial are not evidence. The only evidence that you are to consider in determining the facts is the testimony of witnesses and exhibits admitted into evidence. Your notes are merely an aid to you for recalling trial testimony and the evidence. The law provides for a jury of 12 persons in a case such as this. As I stated at the beginning of this case, we have more than 12 jurors, so that if a juror becomes ill or has a personal emergency, the trial can continue without that juror. In a short time, alternate jurors will be determined by lot in a drawing held in open court. The alternate jurors are still jurors on this case until they are released by court order. Therefore, alternate jurors will remain under the admonition and available to return if needed. I will read the closing instruction after the attorneys have completed their closing arguments. Mr. Martinez.
This individual, the defendant, Jodi Ann Arias, killed Travis Alexander. And even after stabbing him over again, and even after slashing his throat from ear to ear, and then even after taking a gun and shooting him in the face, she will not let him rest in peace. But now, instead of...
All right, we're gonna pause one. We're gonna pause one. We've listened to. We've listened to all of that stuff. All right. Let's see here. I think I said, well, you know what? I've got the quiz party stuff done, so let's do that. There were some of you folks that said, "Hey, this probably isn't right," which maybe. But let's go. All right, it's time to review the answers. I almost said questions, but I guess it's time to review those too. Time to review the answers and give you an updated leaderboard. Whoop, whoop, whoop. All right, so let's start out. So remember again, when we do the quiz on Fridays, you have until the following Wednesday at 8:45 to submit your answers using the Google form that's located on our link tree. Quizzes are awarded points based on how many correct answers you submit. 10 correct is 10 points. This time around, I offered extra and bonus stuff. And at the end of each month, the monthly winner is going to be crowned and points will be reset. At the end of the year, the 12 winners will face off in an epic trivia challenge. All right. So total points up for grabs today was 15. A couple of you actually got all 15. Well done. Well done, you. So let's move on. Okay, so it's okay. True or false? The Eiffel Tower grows in the heat of summer because of the warming of the tower's iron. Bonus point if you can guess within an inch the total amount it grows. Was it true or false? It's true. Some people had written. Some folks wrote in the cell or on the forums feedback like it's been debated. They haven't proven it. I know, but that's generally what I was able to find. So. Yeah, it was a freebie. The total within an inch, the amount it grows is 6. I won't lie, I forgot what my question was, and I went to go look at the answers, and there was a series of cells that just said true 6 inches, true 6 inches, and I was like, what did I ask? That's weird. All right. So up next, what percentage of their lives do sloths spend upside down? The answer is 90. They spend 90% of their lives upside down. Also, they're very cute. And I love the fact that they smile. True or false, the longest recorded flight of a chicken was 13 seconds. And a bonus point if you can tell me a why did the chicken cross the road joke that makes me laugh out loud and embarrass myself wherever I'm scoring the quizzes. Ooh. All right, so true or false? It's true. And some of the jokes, look, copying and pasting. Gotta make my thing a little smaller there. Okay. Why did the chicken cross the road? The chicken's a stalker. That's why he's right behind you. To keep the farm. That's really that on top of the. Never mind. To keep the farmer from choking the chicken, she saw a big cock on the other side. Hold on. Wait a second.
You are tearing me apart, Lisa!
It thought it was an excellent idea to get some toilet paper. That's where JT put the milk duds to give JT a better wig, and it wanted to know what all the jokes were about. There were a couple that came in late. I didn't get a chance to put them in there, but those made me chuckle too. All right, the term mortgage comes from the French roots mort and gage. Gage. This literally translates to death pledge. That's right, death pledge. As in, you're going to be paying this until you die. Probably not even going to be done. All right, a group of flamingos is called a what? A group of flamingos is called a... I guess I'd probably join them. A group of flamingos is called a flamboyance. It surely is. I love that. I just want to join a flamboyance. There's a flamboyance wherever I go. What am I talking about? All right. Next up, true or false, in the 1800s, doctors resuscitated drowning victims by using tobacco smoke enemas. Bonus point if you include a pun with your answer that involves this procedure. Tee-hee. Oh, no. No. If you gave me a joke, I definitely, if I laughed or chuckled or just, if you gave me a good joke, if you made an effort at it, you got the point for that. I just couldn't put everybody's on there. All right. So is this true or false? It's true. I did laugh. Of course I did. All right. So here are some of the puns. Gives new meaning to blowing smoke somewhere. Reanimation. I think that one might have won in my head. Reanimation. They also used to do cocaine, so why not? Something involving poppets. What do you get when the government gets involved in digestive issues? An enema of the state. Blowing smoke up your... I was exhausted after my enema. It took a lot out of me. And holy smokes! I loved it. And all right, moving on. The first recorded use of OMG was in the following decade. Bonus points if you can identify the person who used it. The 1910s. It was in the 1910s. I don't know. And the first, a lot of you got this. The bonus point is it was from Lord Fisher to Winston Churchill. And it says, "My dear Winston, I am here for a few days longer before rejoining my wise men at Victory House. The world forgetting by the world forgot. Da 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 da. This is holding the ring with a vengeance. Are we really incapable of a big enterprise? I hear that a new order of knighthood is on the tapis. OMG. Showered on the Admiralty." My brain. Oof. My brain. All right, true or false, the first webcam was utilized in 1993, where researchers, you think I would have fixed that from last time, used it to monitor a coffee pot. I'm nothing but consistent. It's true. It's true. All right, so this one was contentious. Also, somebody said this is not accurate, so I looked it up. Thanks, Snopes, for proving me wrong. It would have been funny if it was true, though. So, in California, you can't legally buy a mousetrap without having a what? The answer in this case was a hunting license. However, it was proven to be wrong. Somebody pointed it out. And so you get a point, you get a point, you get a point, everybody gets a point. Yay! This is what I used to do in class. Where was the world's first speeding ticket issued? Bonus point if you can tell me within 10 years the year it was issued. It was issued in England. When? It was issued in 1896. Can you imagine? You know what? I can't imagine. I can't imagine at all. All right, so this is these were the standings as of These, you know what? More. The question is, what is the topic? See, look, I'm trying to do this ahead of time. Trying to give you guys a little jump start. So what's the topic? What's the topic? Well, the topic is cult. So we will have trivia questions about cults. That's gonna be fun. So brush up. Brush up. No, I'm not worth getting stolen. They can inherit my debt. That'd be fine. MIA. I'd be easy to lure out into the woods. I'm more street smart than you think. Not by much, but a little bit. So yep. Where do I find them? Either I know them, I've heard them, or I look them up. There's a lot of great websites out there for trivia. Obviously, I will not be using the website from this past trivia because it was wrong. It was wrong. Okay. So there is that. Okay. All right. Now hold on a second. Who's you can't sneak in. It just can't happen. Yeah, I hope so. I hope so at this point. Yes. Yes, I have. You're my friend and I love you. All right, so let's do what I promised. We're gonna hop into the story of Joel Guy Jr. And boy, oh boy, is this something else. Something else. I'm gonna try and make this a little larger. This is a good chunk of reading for me. I don't know if we'll get through all of it tonight. It's lengthy, so we might split it into 2 or 3. I'm not sure yet. Okay. Okay. All right. So let's do a little how to get on to get points. But how do you get on to get points for the quiz? Yeah, so if you want to answer the questions, you go to our link tree and then click on the Night Court Trivia form button, and that will take you straight there, and you just enter your answers there. So if you write your answers down on Friday and then you type in your answers using that form, it automatically comes in. Now, some of you who turned it in, the last 5 of you who turned it in, 4 of you, I don't know, you noticed that there was something that was a little bit different, and that was you have an opportunity to have a confirmation sent to your email. I don't collect those, but it does give you the option to have a confirmation sent to you. In that way, you can guarantee that I have received them. Right now, that's my nice stopgap before the whole showing like a living document that updates. But that is an option now. Yeah, Lisa, you're in I think you're second.
You are tearing me apart, Lisa!
All right, so let's do a little little intro video to this whole Tennessee versus Joel guy. I'm really gonna play on that entire Gru thing. It's way too good. He fits it so perfectly. So perfectly. All right, so let me bring this in a way that you can. Oh, no computer, behave. You don't want to behave. All right, that's fine. Don't. Still not behaving. All right, here we go. So this is the opinion of the appeal. However, it does a really great job walking through everything that happened. We'll do a chunk of this tonight. We'll do a chunk of it on Friday. We might have to do a chunk of it on Monday. But I think it's really important. I've learned that you all kind of like these things. You like this intro. You like some of this research. Brandi does such a good job of it. It's so stressful for me because I'm really not good at this stuff. I do some research. I write some scripts. That's what I do. All right, so here we go. The Knox County grand jury charged the defendant with 2 counts of premeditated first-degree murder, 2 counts of felony murder, and 2 counts of abuse of a corpse related to the deaths and dismemberment of his parents, Joel and Lisa Guy, inside their Knoxville home on Golden View Lane in November 2016. According to the evidence presented at the defendant's September 2020 trial, the victims were planning to retire and sell their home in Knoxville, and they had purchased Mr. Guy's family home in Surgoinsville. It's probably Surgeonsville. Angela Crane, the daughter of Mr. Guy, and the stepdaughter of Mrs. Guy, testified that on November 17th, 2016, Mr. Guy informed the family via text message that the victims sold their Knoxville home and had to be out of the home by December 13th. Jennifer Whited, Mrs. Guy's supervisor, stated that Mrs. Guy submitted her resignation notice on November 21st and that her last day of work was scheduled to be December 2nd. Multiple witnesses testified that either Mr. Guy or Mrs. Guy expressed that due to their retirement, they would no longer be able to financially support the defendant. Ms. Crane testified that Mrs. Guy told her that, quote, it was time for the defendant to stand on his own 2 feet. Michelle Dennison Tyler, the daughter of Mr. Guy and the stepdaughter of Mrs. Guy, stated that in late October 2016, the victims informed her of their retirement plans and told her that the defendant would need to find employment because they would no longer be able to financially support him. Robin White, Mr. Guy's sister, said that Mrs. Guy informed her that upon retirement, she could no longer be able to financially support the defendant and that he, quote, needed to be on his own. Renee Charles, Mr. Guy's sister, testified that 1 week before Thanksgiving 2016, Mr. Guy told her that he and Mrs. Guy planned to tell the defendant at Christmas that he would be responsible for paying his own bills. Merry Christmas. Miss Whited testified that when she and Mrs. Guy discussed the victim's retirement plans, Mrs. Guy stated she would no longer be able to financially support the defendant. Can you tell that this is a whiny man-child yet? Because it is. I'm trying to get it so that it's large enough so you all can see it, and I don't think I'm doing a great job of that, and I'm so sorry. Let's see if I can. Is that maybe that's a little better? Let me fix my let me fix my camera here. All right, here we go. Ms. Tyler testified that she went to the victim's home for Thanksgiving with her 3 sons, and that the family, including the defendant, were together from approximately 10:30 a.m. to 8 p.m. The defendant was staying at the victim's house. Ms. Tyler said that the defendant typically remained in the bedroom and did not spend time with the rest of the family, but that, quote, Thanksgiving was completely different. The moment that I arrived, the defendant was talking to us. She said that Mrs. Guy had kept everything that the defendant had collected and had memorialized. His, quote, his entire life in boxes upstairs. The defendant and Miss Tyler's sons brought the boxes downstairs, and the defendant gave his toys and games to Miss Tyler's sons, which she believed to be odd. Miss Tyler brought her laundry to do at the victim's house because her dryer had broken. When she parked her car, tale as old as time. When she parked her car near the home so that she could easily take all of her clothes to the laundry room located upstairs, she saw big totes in the back of the defendant's vehicle. One tote was inside the other, and the lids were on them. She went upstairs at the victim's house to do laundry and to check on her children because she found it odd that they were interacting with the defendant. The defendant was staying in the bedroom near the top of the stairs, and Miss Tyler said that every time she went upstairs, the defendant was right behind her, which she found to be strange. I agree. If you guys like this, listen to Active Shooter, the podcast. It's the same. While upstairs, Miss Tyler entered the victim's bedroom and noticed nothing out of the ordinary, recalling that the bed was made and that the bathroom was clean. The upstairs area also included a bathroom attached to the victim's bedroom, another bathroom located down the hallway and to the right from the bedroom where the defendant was staying, and a laundry room located across from the second bathroom. She said that the victims had a dog that they pampered and would never lock inside a room. Miss Tyler testified that Mr. Guy owned a large number of guns that he kept loaded, but she did not see any guns lying out over Thanksgiving. Mr. Guy also had security cameras inside the house, which were present over Thanksgiving, but were missing when Miss Tyler returned to the residence with police after the victims' deaths. Miss Charles testified that on Friday, November 25th, 2016, which was the day after Thanksgiving, she spoke with Mr. Guy, who stated that the victims planned to go to Surgeonsville, I'm going to call it Surgeonsville, why not, and to return to Knoxville at approximately 3 p.m. Miss White, that name changed, but we're going to go with Miss. That was my ninth grade math teacher. Miss White spoke to Mr. Guy via telephone at approximately 1 p.m., and Mr. Guy stated that he and the defendant had brought Mr. Guy's boat to Surgeonsville and that they planned to leave soon. Miss Charles called and sent text messages to Mr. Guy on Saturday and Sunday, but he did not respond. The victims also did not respond to Miss Tyler's calls and text messages over the weekend. Shondice Fink, the daughter of Mr. Guy and the stepdaughter of Mrs. Guy, testified that although she spoke to Mr. Guy almost every weekend, she did not hear from him on Saturday or Sunday, which surprised her because Sunday was her birthday. We're back to Mrs. Whited. Miss Whited testified that Mrs. Guy was scheduled to begin work at 7 a.m. on Monday, November 28th, but never arrived. At approximately 7:15 a.m., Miss Whited began sending her text messages, but Mrs. Guy did not respond, which Miss Whited believed was highly unusual. Miss Whited continued sending text messages to Mrs. Guy as well as Mr. Guy, and she called but did not receive a response. Miss Whited said that it was unusual for Mrs. Guy to miss work without notice, and concerned for Mrs. Guy's well-being, Miss Whited called the police and requested a welfare check. After some time had passed, and Mrs. Whited was still unable to contact either of the victims, she contacted the police again and asked what officers found during the welfare check. Miss Whited was told that, quote, everything seemed to be fine, that nothing looked out of place. She asked the police to return to the victim's home because she knew something was not right. She said that Mrs. Guy had plans for a retirement lunch with coworkers that day, and that she would not have canceled or just blown them off without calling. Approximately 30 minutes later, a detective contacted Mrs. Whited and asked additional questions about Miss Guy, but Mrs. Whited was unaware of anything that occurred. Mrs. Whited said that Mrs. Guy's employment benefits included a $500,000 life insurance policy and that Mrs. Guy had elected to split the payout of the policy evenly between her designated beneficiaries, Mr. Guy and the defendant. Miss Whited did not know whether the defendant was aware that Mrs. Guy had designated him as a beneficiary for her life insurance policy. Miss Tyler testified that on the Monday after Thanksgiving, she planned to go to the victim's house after work to check on them if she did not hear from them that day. That afternoon, Miss Whited told her that, quote, there's something wrong, and that she needed to contact the detectives. Miss Tyler met with a detective and recounted the events of the Thanksgiving weekend and told him that the defendant had been present. Miss Tyler said that she was appointed as the executor of Mr. Guy's estate after his death, and that she became aware of large payments that had been made out of Mr. Guy's account after his death for utility and for school at Louisiana State University, as well as a $10,000 payment to the apartment complex where the defendant lived. Good grief. Good grief. Sir Goinsville. Thank you. Thank you. I'm having a moment to be able to look at the quote. Teresa, it's your birthday? Oh, it's in 2 days? Sweet. Friday. Teresa, will you be here on Friday? I hope not. I hope you're celebrating your birthday. You know what? Let me assume that you won't be, and let me just say happy birthday to you. Happy birthday to you. Happy birthday, dear Teresa. And Tommy. Yep. Happy birthday to you. Knox County Sheriff's Office, KCSO, Detective Stephen Ballard, a patrol officer at the time of the victim's deaths, testified that he responded to the victim's residence on Golden View Lane for a welfare check on Mrs. Guy. He knocked on the front door and rang the doorbell, but no one responded. He walked around to the side of the house and saw a small fence surrounding the backyard with a locked gate. He saw a dog house in the backyard and whistled for the dog, but he did not receive a response. He returned to the front of the house and again knocked on the door and rang the doorbell to no response. The house had a for sale sign in the front yard. Vehicles were parked in the driveway, and the light in the foyer was on inside the residence. He estimated that he was at the residence for 5 to 10 minutes. Yes, it is. It is the majority opinion of the appeal of Joel Guy Jr. walking us through every day. It depends. What do you want? And do you have 35 cents? KCSO Detective Jeremy McCord, the lead investigator in this case, testified that he was notified on November 28th, 2016, that Mrs. Guy's employer was concerned because she did not come to work that morning, even though she had a lunch or event with co-workers planned. He learned that Mrs. Guy's failure to show up for work or answer telephone calls was uncharacteristic of her. He learned that Detective Ballard had conducted a welfare check earlier in the day, but that the caller continued to insist that something was wrong. Detective McCord, Detective Ballard, Officer Jared Graves, and Officer Benjamin Gresham went to Golden View Lane residence to conduct a welfare check. Detective McCord testified that upon his arrival, he noticed vehicles parked in the driveway and a for sale sign in the front yard. The back fence was closed. I like this, and hopefully you're not entirely bored, but I like this because it is a narrative, because it's readable, it's listenable. It gives us pretty much a play-by-play. All right, the back fence was closed, the front door was locked, and groceries were visible in the front foyer of the residence. He also noted that despite the sale sign in the yard, there was no realtor box on the front door. Detective Ballard testified that he and other officers spoke with some of the victims' neighbors to determine when the victims had been seen last. Detective McCord testified that because the vehicles, which he determined belonged to the victims, were in the driveway, he believed the owners of the victims could be inside the residence and need assistance. He and Detective Ballard climbed over the fence into the backyard, and Detective McCord saw that the back door was missing a doorknob, and that, quote, the glass was warm from the inside of the house. He also noticed some kind of strange odor, which he described as chemical in nature. He described feeling very odd about the circumstances and noted that there was something ominous about it. He called the realtor, who told him that a lockbox should have been on the front door and suggested another avenue of entry was possible. Detective McCord observed that the front doorknob did not match the deadbolt, and stated that someone appeared to have removed the doorknob and lockbox from the front door and replaced the doorknob with the doorknob from the back door. An officer located a garage door opener in one of the vehicles and opened the garage door. Detective McCord said that, quote, as soon as the garage door was opened, you could feel heat. He decided to enter the residence to conduct a welfare check. All right, y'all, we're getting into it, so I am going to pop that up. If this ain't for you, that's totally fine. I get it. The officers entered through the interior garage door, which was unlocked, and Detective McCord announced the presence of law enforcement as they entered. Detective McCord said that they were, quote, immediately hit with odor and heat. Very extreme heat. Detective Ballard also observed containers of chemicals on the floor and stated that from the time he entered the residence, he felt a tingling on his forehead due to the smell of chemicals. Immediately inside the door, Detective McCord saw bottles and various other items on the floor and a purse and 2 wallets on the table, which further alarmed him because most people have their wallets when they leave their residence. In the kitchen, he saw a pot on the stove and noticed that the stove and oven were on. He saw what appeared to be feces on the living room floor. He noticed perishable items among the groceries on the foyer floor, and he saw a large number of long guns on the dining room table. Detective McCord stated that nothing that he was observing made sense. I would say so. Yeah, buckle up. Shanka, you got a birthday today too? No? Yes? Monday? All right. Remind me. Y'all, I got bad memory. Y'all know this. All right. I hope it's like a 5 point. All right, here we go. The officers moved up the staircase with Detective McCord leading, and the detective noted that the upstairs was hotter than the downstairs. He heard a dog barking and said that the dog would bark for a period, stop, and then whimper. He noticed a stain of what appeared to be blood on the wall of the stairwell. At the top of the stairs, he observed clothing, sharp instruments, a bucket, and reddish-brown staining on the floor, the wall. It's going all over the place. As he looked down the hall, he saw hands not connected to a body. Detective McCord entered the master bedroom where he saw a roll of plastic on the bed and items scattered on the floor. As he entered the ensuite bathroom, he saw an array of tools and lights on the floor, knives, and 2 tubs with what appeared to be body parts liquefying. He noted that the bathroom was hotter than most places in the house. At that point, he instructed the officers to exit the residence the same way in which they entered. He reiterated that his purpose during the initial entry into the house was to make sure the people are okay if they're inside. Once he saw the scene upstairs, he became concerned with preserving the crime scene. Well done. Well done. He acknowledged that the officers did not fully clear the house during the initial entry, particularly the room where the dog was eventually found, explaining that, quote, out of an abundance of caution, I made sure that we had enough personnel for safety to safely clear that room. Upon re-entry with additional officers, he cleared the laundry room, finding only the dog. I believe the dog was fine. So everybody can breathe. Everybody can breathe. Sam, I read that in a completely different fashion.
Not today, Satan. Not today.
I even knew that he does that. And I went a completely different route. All right. At some point, Detective McCord returned to the kitchen, looked in the stock pot that was on the stove, and discovered a severed head. The Regional Forensic Center personnel removed the body parts from the scene, and the liquids in which the bodies were found were placed in a container by the Environmental Protection Agency for storing biochemical components. Officers with the KCSO Forensic Services Unit processed the crime scene at the Golden View Lane residence. Officers collected Y'all, I laughed so hard. So hard. They collected 3 gasoline cans from Jodi. Y'all didn't think we were going to do gas math, did you? Here we are. They collected 3 gasoline cans from the garage that were each filled with approximately 15 gallons of liquid believed to be gasoline. 15 times 3, 45? All right. Officers also located a small piece of paper towel with reddish-brown staining and what appeared to be bloody shoe print in the garage. Entering the residence through the garage and into the kitchen, officers observed 2 wallets, a set of keys, vice grips, a hammer, a magazine, a purse, and money on a table. One of the wallets contained the driver's license of Mrs. Guy, and the other wallet contained the driver's license of Mr. Guy. Never a good thing. A bleach spray bottle, a bag of trash, towels, rolls of trash bags, 3 containers of bleach, a bottle of muriatic acid, an unopened container of baking soda, and a lighter were on the kitchen floor, and a partridge in a pear tree. A red cellular telephone, a pair of blue disposable gloves, and an empty prescription bottle for Joel M. Guy were on the kitchen counter. A doorknob and a realtor's lockbox were in fluid in the kitchen sink. The stove was on, and a large stock pot with a lid was on the stove top. Dude, this guy, man. Guns and boxes. Everybody's saying we didn't come here to gas math. I agree. I didn't either. But here we are. Guns and boxes of ammunition, a part of a doorknob, and a screwdriver were in the dining room. Forensic officer Sandy Campbell testified that it was, quote, very, very warm inside the house, and that the downstairs thermostat located in the foyer by the front door was set to 90 degrees. Groceries were on the floor of the foyer. The perishable items, including bacon, sausage, lunch meat, and ice cream, were no longer cold, and the ice cream was completely melted. Officer Campbell observed reddish-brown staining, which appeared to be blood, down the side of the wall leading up the staircase, on a child safety gate, on the banister, and on the wall at the top of the stairs. Clothing that had been cut, 2 black Nike tennis shoes with staining, and a cast iron were in a pile on top of the stairs. An empty bottle of crystal drain opener that said Lye 100%. Several empty 6-pound, 8-ounce containers of number 2 sewer line cleaner. A stainless steel kitchen knife and scissors were also at the top of the stairs. You see where this is going, I think? Yeah. All right. Officer Campbell heard a loud noise from the master bedroom and found a heater turned on. Can you imagine walking through this and hearing a loud noise? Officer Campbell heard a loud noise from the master bedroom and found a heater turned on its highest setting and blowing in the room. A large amount of items were piled on the bedroom floor, including 2 black trash bags, an empty package of Clorox gloves, a Walmart bag containing gray workout pants, a gray long-sleeve t-shirt, and 2 pairs of gray socks, a 3M dust mask, an unopened gallon container of liquid fire drain line opener, Flexon hose packaging, an HDX extension cord, Sharpie marker, safety goggles, a Defiant heavy-duty timer, a shower head, vice grips, a piece of plastic packaging, 3 unopened bottles of food-grade hydrogen peroxide, 2 glass dropper bottles, a large roll of clear plastic that appeared to have been cut, a mountable heater, a Baco work light, a glass bender pitcher and Breville blender base, stuffed animal toys, a hammer, a flashlight, light bulbs, an empty sprayer bottle, and 2 Post-it notes with handwriting. Whoa. Yes, always a Walmart. Always a Walmart. Always, always. It never fails. While heading into the ensuite bathroom, Officer Campbell saw plastic sheeting on the floor that appeared to match the roll of plastic sheeting found in the bedroom, and 2 large Rubbermaid type tubs. Both tubs contained body parts and liquid and were kind of bulging on the sides. The shower head had been removed inside the bathroom, and a garden hose type thing had been attached in its place. Dishwashing gloves were on the bathroom counter, and a kitchen knife was in the sink. Officer Campbell found another heater inside the bathroom that was not on at the time. but she noted that the master bedroom area of the house was the warmest part of the house and that the upstairs was warmer than the downstairs. The upstairs thermostat was set to 95 degrees. He really missed a chance to reference a boy band there. In the second bedroom, which Miss Tyler had identified as the bedroom where the defendant had been staying, Officer Campbell found, now this is where Joel was staying. Campbell found reddish-brown staining on the floor, a suitcase, tops to blue Rubbermaid containers that were similar, if not the same ones, as found in the ensuite bathroom, textbooks, 4 prescription bottles, some of which are for Joel M. Guy and one of them's for Lisa Guy, a box of Hornady critical defense buckshot 12-gauge 80 pellet ammunition, an open box of medical-type gloves, an unopened package of Clorox brand gloves, a container of food-grade hydrogen peroxide with reddish-brown staining, a backpack, reddish-brown staining on the bed, a laptop computer, a towel with staining, a Walmart bag containing a Baco work light, an open container of food-grade hydrogen peroxide, and a single blue glove. Inside the suitcase, she found a post-it note that had a handwritten address for Dan Boudreau's Ace Hardware in Napoleon, Louisiana, and stated Rudo, 6.5 pounds sewer line cleaner, 1999. Also among the contents of the suitcase, she found gray Banana Republic underwear and a knife sheath stamped with USMC. You're going to find this. You're going to find out that Banana Republic underwear are all throughout this. It's great. In a third room that was located across the hall from the second bedroom and was being used for storage, Officer Campbell found reddish-brown staining on the door frame and a Miracle Blade 3 knife, a towel and a pile of clothes that included 2 pairs of gray Banana Republic underwear and a white t-shirt were on the floor of the upstairs hall bathroom. Several items were on top of the vanity, including a set of keys to a Kia car, a Samsung Galaxy S5 cellular telephone, a 16-ounce bottle of hydrogen peroxide, multiple blue disposable gloves, Charmin wet wipes, multiple pieces of medical tape, zinc ointment, a sock, cash, and coins. There should never be a sock in a bathroom. If you walk into a bathroom and a sock is saying hello to you standing up, don't touch it. Sorry, I need to lighten the mood somehow. Good grief. Cash and coins, first aid tape. Budgie. A knife marks USMC and 6 spacers. A receipt from the Walmart on Parkside Drive indicating a purchase at 3:35 p.m. on November 26th. That would be the date of the murders. 2 16-ounce bottles and 1 32-ounce bottle of 91% isopropyl alcohol, triple antibiotic ointment, Dermoplast pain relieving bacterial spray, and a large amount of reddish-brown staining. Somebody hurt themselves. Tell me that's a joke. Did that really happen? Was that really sad? Because that's hysterical. That is absolutely ridiculous. All right. In the laundry room, Officer Campbell found a gray fleece blanket, a brown fleece blanket, 2 white washcloths, 1 sock, and there's where the other sock went, and 2 pairs of gray Banana Republic underwear. This is not the advertisement that they want, but feel free to sponsor us. That were similar to those found in the hall bathroom. In an exercise room at the end of the hall, she saw a pile of clothes with staining and a couple of knives, including how many knives exist in this house? Good grief. Including a Victorinox kitchen knife and a stainless steel kitchen knife. Some of the clothing had been cut. She noticed a large amount of reddish-brown staining inside the room, and she found a white hand towel with staining and, quote, a set of what appeared to be male human hands that were severed from any other part. Retired KCSO Officer Thomas Finch, an expert in fingerprint examination, identified 6 prints from the scene as belonging to the defendant, including prints found on a package of Clorox gloves, a package of Charmin wipes, a tape package, a box of gloves from the dresser in the upstairs guest bedroom, and a palm print from the upstairs hall bathroom. Oops, he did it again. I hate these guys. They think they're so smart. Oh, we're getting to insane stuff. KCSO officer Rachel Smith testified that on November 30th, 2016, she photographed and inventoried evidence at the forensic laboratory. Inside the purse collected from the eat-in kitchen table, she found a grocery list and a receipt from the Walmart on Parkside Drive from November 26, 2016, 12:18 p.m. That's the same day as the murder. At the laboratory, she photographed and opened a maroon backpack collected from the upstairs guest bedroom where the defendant stayed. Inside the backpack. Huh. Yeah. Yeah, that's a thing, for sure. In terms of Kohlberger, this happened in 16, so, yeah. Oh, this is the ridiculous part, y'all. This is the ridiculous part. There's so much ridiculous. So she looks inside the backpack. She found a calculator. Everybody's got to have a calculator. An instruction. By the way, Texas Instruments calculators are now in color. Who decided that calculators should be in color? Just pull out your phone. There's a reason why Joel and Chandler were up versus each other for the vote to see what we covered. Yep. All right. Here's what she found inside the backpack. Calculator, an instruction manual for a residential gas water heater that had been printed on November 23rd, 2016 at 4:12 p.m. Black notebook, a book from a co-op bookstore in Baton Rouge, an umbrella, a computer mouse, and several books inscribed with the name Joel Guy on the inside covers. The black notebook contained a syllabus for a fall 2016 class, pages of math problems and handwritten notes, the legible portions of which said the following: bullet points, underlining, strike-throughs, and other markings in original. Oh boy. You know, I've heard of being organized, but obviously he wasn't. But this list: get killing knives, quiet, multiple. Get carving knives to make small pieces. Get sledgehammer, crush bones. Bring a blender and food grinder, grind meat. Get bleach, denature, I don't know, denature proteins. I'm not a scientist. I just play one. Get plastic bin for denaturation process. Does not matter where they're killed, just get rid of the bloody spots to prevent evidence of time of death, not the mattress or couches. I don't think he did that. Get rid of bodies inside house. There and my DNA are already there. Open up a doggy door to provide entryway. There are some strong parallels. I will just leave it at that. I'm waiting to see the doggy door emojis. Oh wait, maybe I took them away. I might have removed the doggy door. Nope, it's still there. There it is. We're a little just a little behind. All right. Flush. These are his words, not mine. Flush chunks down toilet, not garbage disposal. Get plastic sheeting for disposal process. Get hollow point bullets just in case. Will be seen buying bullets. Just use computer room gun. Check to make sure there are bullets. Last resort. He's not alive to claim her half of the insurance money. All mine. $500,000. Can you? I can't. Like you knowing that this was a case, like you probably heard the whole he and his dad were like beneficiaries, and you were like, oh well, there it is. Flood the house. Turn heater up as high as it goes. Speeds decomposition. Bleach reacts with luminol just like blood. Douse area with bleach. Big sprayer. Lie. Trash compactor. Body gives time of death. Alibi. Don't have to get rid of body if there is no forensic evidence on the body. His fingerprints and DNA. Minimize things I touched throughout visit. Don't think that happened. Wear gloves and socks to prevent fingerprints and footprints. Also didn't happen. Drop something down the garbage disposal to break it. Get him on the ground fixing it. Kill him with a knife. Clean up mess from him before she gets home. Kill her with knife. Kill dog after. Leave alive. Take dog with you. What? Oh, okay. So he wrote that he was going to. Yes, there is. Sorry. Sorry, I'm looking at this and the chat's over here. Yes, we are going to be watching the trial of Tennessee v. Joel Guy Jr. We are 100% just reading this is the appeal majority decision, but it gives us a narrative of what was found and what happened. So I'm glad that he crossed that out. I mean, he's a poo-poo head. So we decided to take the dog with him. Place her in shower, turn on hot water, and point at her to get rid of forensics. Remove her clothes and take them with me for disposal. Place him in plastic bin and use it to get him into the upstairs bathroom. Cut off his arm and plant his flesh under her fingernails. Place her hand with his DNA so that his DNA is not washed away by shower. Use sodium hydroxide to destroy his soft tissue and soften bones for transport. Based once every... Is he serious? Is this... Y'all. I obviously didn't make it this far. But I figure it's more real if I read it along with you. Based once every hour to accelerate. Flush sodium hydroxide down the toilet. That sounds like a great idea. Wash out bin with handheld shower head, and then direct handheld into toilet to flush everything out of the pipes and into the public waterway. Douse killing rooms. Kitchen with bleach. Place hair curler with flammable paper and flammable containers of gasoline in 4 locations. Now hold on, sir. You had 3 cans of gasoline, not 4. His killing room, her killing room, his bathroom, her bathroom. Wipe down areas near killing rooms and bathrooms. Turn heaters up to 90 degrees to melt fingerprints and dry everything. Set her phone to send me a text message late Sunday to prove that I was in Baton Rouge and she was alive. Leave through front door and wipe down doorknobs. Timer for flammables sent for Friday at 10 a.m. so they can't report it. Another page of the notebook had the following handwritten notes. Ultraviolet light shows fingerprints. Check mail before leaving. To get rid of blood, use peroxide and bleach. Another page of the notebook had handwritten notes with the heading Destruction of Bodies and listed the percentage of fat, protein, water, and other compounds in the human body. The last page of handwritten notes listed victims' assets as follows. Her assets. Her life insurance, $500,000, possibly more with double indemnity. With him missing, dead, I get the whole thing. All her other assets are joint. Go to him if missing, unknown if he is dead. His assets includes all joint property if missing. When he gets all joint property, also gets joint debt. Knoxville house, homeowner's insurance policy, but probably worthless after fire, owe $100,000. Sirgoinsville house, appraised at $400,000 plus, worthless with Renee on property. Worthless with Renee on property. Or what is that? Okay. Her car, his SUV, his boat, his old truck, his 401k is $80,000, possibly left after taxes. He could possibly have savings and or investment accounts. Officer Sandlin said that much of the evidence recovered from the victim's residence corresponded to the notes in the black notebook. On December 1st, 2016, Officer Sandlin searched Mrs. Guy's red Kia Sportage, finding 2 bags and receipts from PetSmart on Parkside Drive from November 26, 2016 at 11:23 and 11:26 a.m. All right. We're going to do this last paragraph. Special Agent Kim Lowe of the Tennessee Bureau of Investigation, TBI, an expert in serology and DNA analysis, determined that the scissors recovered from the top of the stairs had the blood of Mr. Guy and the defendant on the blade and the blood of Mrs. Guy on the handle. A knife recovered from the top of the stairs had Mr. Guy's blood on the blade and Mrs. Guy's blood on the handle. Pieces of medical tape and several gloves collected from the upstairs hall bathroom had the defendant's blood and DNA. 2 gloves collected from the upstairs hall bathroom had Mrs. Guy's blood, and at least one of the gloves also had the defendant's DNA. The DNA of both Mr. Guy and the defendant were on the fingernail clippings from Mr. Guy's right hand. The defendant's blood was also found by the child safety gate at the top of the stairs, on a knife collected from the primary bedroom, and on at least one other knife, a knife collected from the bathroom off of the master bedroom, had the blood of the defendant and Mr. Guy. The blood on the wall of the exercise room belonged to Mr. Guy. The black notebook collected from the backpack contained the defendant's DNA. Because he was so full of himself. Just so full of himself. Ugh, I have no patience for people like this. Obviously. Oh, right? Right? Like, there's like only one way this could have went, right? In my book, anyways. All right. So, all right, everybody take a deep breath. Deep breath, deep breath. Yes, he just happened. He just happened into, it's that whole like Moulin Rouge. He ran into my knife. He ran into my knife 10 times. He had it coming. He had it coming. He only had himself to blame. All right. I love you guys. He really did. He thought he was so ready. He's just one of those guys who I feel like he doesn't leave his room, which is fine. We don't all need to leave, but he also like watches like, I don't know, Criminal Minds and is like, I got this. But he's a whiny man child. Just a whiny man child. His parents said, we can't support you any longer. We're retiring. You're 28. And blah, blah, blah. Yes, one of my favorite songs. Give 'em the old razzle dazzle 'em. Hello. All right. So let's take a deep breath. Take a deep breath. All right. No, he did not get the death penalty. He got life imprisonment. Yep. Sure is. Just whiny. Okay. Kelly, I saw you post that, and then I saw you retract it. All right, we gotta find some sort of center. We're definitely, so after that, you can see why I said in between that and then the actual closings, I'd like to do something, meditation wise for everybody. So we need to take a couple deep breaths. I need to take a couple deep breaths and calm myself down. Okay. Now remember, for some of you, this will work. For some of you, it's a hard time. If when we do this, so listen, I'm not great at this. That's why I'm talking and not listening. But if you have a thought come in your mind, allow that to happen. And then just kind of set it aside. If you have another thought come into your mind, let it happen and set it aside. You're not failing if your mind is not thoughtless. You know what I mean? Like, you're doing fine. All right. So 1876. It was a good year, right? 1876. Okay. I'm going to be real embarrassed if you couldn't hear any of that, me talking. Because if that's the case, that was a waste of 14 minutes. I am not asleep in any way, shape, or form. You couldn't hear me talking. That's awesome. Great. What a waste of my time. I literally read the whole script. Well, go subscribe to my corroborating consciousness, and I will re-record it. Wow, I'm so sorry, everybody. What a waste of your time. My bad. But maybe you had some music and, you know, some scenes. I'll kick myself later. Probably pretty hard.
A gun instead of a knife. She uses lies. And she uses these lies in court when she testified to stage the scene for you, just like she staged the scene for the police after she killed Mr. Alexander. And this woman who would stage the scene has even attempted to stage the scene through the use of the media. She has courted the media. She has gone on national television. You've seen the programs and you've seen some of the her words to the media. She has also attempted or gone out in search of the limelight. She has signed a manifesto just in case she becomes famous. And to top it all off, she has indicated that she is innocent, that no jury will convict her, that none of you will convict her after she has staged the scene for you. Well, she is an individual, as you have seen, who has craved the limelight. So it seems that it is only fitting that this individual that has craved the limelight, it is really only fitting that she now bask in a different kind of light, the light of truth. And in the light of truth, you can see who she really is. She's an individual who is manipulative. This is an individual who wants to play the victim, even though there is no abuse, as you heard from those that know her. She's an individual that, according to her own statements in an email on Valentine's Day of 2007 to Mr. Alexander, said that she was destructive. She's the individual that talked about what she did to doors, what she did to windows. And she's an individual that does not appear to be very nice to her mother, because she lashes out at her and strikes her physically. Additionally, when the light of truth is shining on her, she is somebody who is just an individual that manipulates people. That, for example, when she's speaking to Mr. Alexander during that fateful May 10th, 2008 conversation, that she talks about her sister and says how dumb and stupid her sister is. This is an individual who is manipulative, This is an individual who will stop at nothing and will continue to be manipulative and will lie at every turn and at every occasion that she has. One of the examples is the issue of the gas cans. She indicated to you from the witness stand and looked at each and every one of you after having taken the oath and said, yeah, I bought the gas can, all right. And I bought it from the Salinas Walmart. I did buy it from the Salinas Walmart, but after being questioned by the prosecutor, I took it back and I received cash. Yet you heard from Amanda Webb, the individual or the woman who works for Walmart, checked each and every single register, even those that were not geared to give refunds, checked each and every single register. And each one of those registers indicated, no, there had been no such refund. And then, of course, you could have the confirmatory action in Salt Lake City after first indicating that, no, I've never been in Salt Lake City. I've never put gas in Salt Lake City. But you saw the receipts that she had. And not only had she put gas into her car in Salt Lake City, she had two other transactions. One for 5.09 gallons of gas, and then one for slightly under 10 gallons of gas. She looked at each and every one of you, this person, and attempted to manipulate you. Well, this individual that attempted to manipulate you believes, based on what we've heard, that even though she may have engaged in actions, she may have done certain things, none of it, absolutely none of it, is her fault. Why could it possibly be her fault? If you look back in her history, which is the important part of it, involving her relationship with men, what do you see? Well, even when she was young, she had this personality of manipulating the facts. Back when she was with Bobby Juarez, what did she tell you? Well, this was an individual that was unfaithful to me. How could he be so unfaithful to me after I've done so many good things for him? I've tried to buy him clothing. I've bought him food. I even lived in a trailer that was so bad and it was infested. Never mind that the reason that I moved there was because I was skipping school. No, that wasn't my fault at all. No. I was doing this for Bobby. And how does he repay me even though it wasn't my fault? Well, you know what? He goes and he he sends letters to another woman over the internet. It isn't her fault that she found out about it. Of course not. How could it be her fault that she found out about it if the library doesn't have enough security attached to that particular computer to have some sort of device attached to it so that somebody can't come along and just hit that backspace button so that whoever was using it before, maybe one or two or three or four people before that, somebody can just come along and hit that backspace button. It is eerily reminiscent of what she told you happened in February of 2007, where after she and Mr. Alexander began dating, that she went onto his computer and began to hit that same backspace button. It's not her fault that computers have not been improved since the 90s or the 2000s, such that you can't stop hitting that backspace button. It's not her fault that that happened, of course not. That's what she told you from the witness stand. And so, according to her, she hits the backspace button, and there it is, this conversation between Bobby Juarez and somebody else. But that's not her fault. But if you remember how aggressively she reacted to that, nobody was going to do anything to her, or nobody was going to be putting her or sliding her or putting her in a position of feeling inferior, if you will.
It was disbarred.
She immediately went to Bobby Juarez and did something about it.
Made some really
There is a
dumb
pattern
decisions.
because the same thing happened with regard to Matthew McCartney, the person that she jumped to after she and Bobby Juarez started to have problems. And I do say jumped to because when she was dating Bobby Juarez, he moved away to Oregon. And when he moved to Oregon, he started living with a guy by the name of Matthew McCartney. And when this thing soured with Bobby Juarez, she immediately went with Matthew McCartney. And in terms of that relationship, the reason that that broke up, it's not her fault. Just like it wasn't her fault with regard to Bobby Juarez. It wasn't her fault at all that she had these issues with Matthew McCartney. No, She can't help it if she is a good worker. She can't help it if she's working as a waitress and people come by when she's working as a waitress and try to tell her things about her boyfriend, Matthew McCartney. She can't help that. That's what she wants you to believe. And again, isn't that reminiscent of what happened involving Mr. Alexander? It seems that this is cyclical, and it seems that the story repeats itself. And it repeats itself because she's lying. And it repeats itself because she's trying to manipulate you through all of the days that she spent talking to you from the witness stand after she had taken an oath. Well, she gets to the point where she moves to Palm Desert in California to be with an individual by the name of Daryl Brewer. And of course, when she's there with Daryl Brewer, it's not her fault, again, that relationship is souring. No, not at all. It's not her fault because, well, Mr. Brewer doesn't want to marry her. What's a girl to do? It's not her fault. She's got to look for another guy. And it appears that he doesn't want to have any kids, and she does. And so, again, it's not her fault. How could it possibly be her fault that somebody has free will? Absolutely not her fault. That's what she tried to tell you. But resourceful as ever, resourceful as she's always been, this person who is manipulative, she starts looking around for somebody else and decides that perhaps those boys from the Mormon faith are a pretty good catch because those boys, they have a lot of family values. And these boys, they work, they seem to be very successful. They just seem to have everything that she desires in a husband so that she can breathe. And so what she decides to do is to look for one of those boys. And to Travis Alexander's misfortune, he was that boy. And he was that boy back in September of 2006 when he was at this PPL convention, the yearly convention. Yes, he is the individual that went up to her and they began to talk. And such is the way that things began between the two of them. She wanting to find a boy just like him because she had an ulterior motive. She wanted somebody that was Mormon. She wanted somebody that she could give her a child. And so this seemed like the perfect catch for her.
Everybody.
And although she tells you that, well, he kind of was the person that pushed her in this relationship and that he was the individual that somehow was this person who was so sexually interested in her. And oh, by the way, she wasn't. That it's not her fault that any of this happened. Of course, none of it is her fault. Never occurred to her that in the lexicon of the English language, there's a word. It's called no, that you can use when you don't want to do something. And yet you can then take the witness stand, however, and say, well, I do know that word, but just chose not to use it. But it's not her fault. Again, it's not her fault. It's Mr. Alexander's fault for being interested in her. Don't you see? Can't you all see, based on those days and days that she was on that witness stand, that it isn't her fault? She was thinking no, or at least that's what she told you. This person who told you also about the gas cans. Over and over again, she kept saying with regard to each and every single repetitious sexual act, with regard to each and every one of those, no. I was thinking no. Really, that's exactly what you were thinking. Did you ever communicate that to him? No. This from a woman who is manipulative.
This is literally the calmest one has ever been.
Pretends to be the victim, even though there is no abuse. And so throughout this early part of the relationship, which some would call the honeymoon portion, during this part, it appears that they do what two people that are young and are involved in a relationship do. They engaged in relations. But there's this finger-pointing aspect to this relationship as portrayed by the defendant. Can't point the finger enough at Mr. Alexander, can't point the finger enough at the fact that, he's a bad Mormon. Because he's having sex with me. If he's such a bad Mormon, then why stay with him? You're the one that chose him. If he's such a bad guy, why are you hanging out with him? And to compound things, well, she's also Mormon too. Why does she keep pointing the finger at him when she is just as Mormon as he is. She converted in November of 2006. And according to Deanna Reed, there are many classes that tell you about the law of chastity, and they tell you about the law involving sexual intercourse. But wait, it's not her fault. How could you possibly think it was her fault when those 3 or 2 Mormon missionaries that came over didn't tell her about it? Again, it's not her fault. Although there are all these classes where they talk about it, no. Let's point the finger at Travis Alexander, because according to her, he's the bad guy. He's the one that told her that it was okay, and so she's going to go along with what he says, even though those in the Mormon church are telling her otherwise. It is almost unconscionable for her to point the finger at Mr. Alexander when she's in the same situation as he is. She has the same knowledge that he does. But again, she wants you to feel sympathy, because again, it's not her fault. You know, how could it possibly be her fault when she was thinking, no? Well, luckily for Mr. Alexander, I guess, in the beginning, this relationship was from a distance. And I say luckily because at least when she was in Palm Desert, and he was in Mesa, Arizona during that time, at least during that time, she couldn't reach out and stab him. She couldn't reach out and shoot him in the face. She couldn't stalk him. Couldn't come over unannounced. She wasn't living the 10 minutes away. At least fortunately, during that time, Mr. Alexander had some extra time to live. And during that time, they were not mutually exclusive. So yes, it is appropriate when they are not mutually exclusive for an individual to send text messages to other women, if they are male or even if they are not. There's nothing wrong with that. But if you see that long finger pointing from the witness stand to him, how could he possibly, when we were together, how could he possibly, before we became exclusive, be talking to other women? How could he be on the internet? How could he be sending text messages? But it's okay, don't you see, that when she goes to his memorial service, talking about Travis Alexander's memorial service, after she killed him, it's okay for her to talk to somebody on the airplane, to get a telephone number. It's not her fault that this guy was trying to pick her up. Of course it's not her fault. And what's a girl to do after all? The guy that she was involved with up and died after she stabbed him, slit his throat, and shot him. What is she to do? Can't you see that it really isn't her fault? At least that's what she wants you to believe. And during this period, Mr. Alexander did see her. And during this period, Mr. Alexander did engage in sexual contact with her. There's nothing, absolutely nothing important about that as it applies to the killing, other than to try to manipulate you, try to shock you and say, oh my gosh, look at this guy. He wants to kiss her and he wants to do other sexual things that other people do in their private lives. And he doesn't want to talk about it, for God's sake. But he doesn't want people to know what it is that they're doing. Why would he want anybody to know what he is doing sexually and with whom? Is that something that this is courteous in this society to do? It's just the opposite. But she has now turned the world sideways for you to look at that in an attempt to manipulate you. Well, they continue on with this relationship, and she lives out in Palm Desert. At some point in February of 2007, after this issue involving the February 14th mailing that she indicates that she receives, after that, they make the relationship, if you will, exclusive. What's interesting about the email from February 14th of 2007, and you saw that, is that not only does it talk about her violent tendencies, it does talk at length about that, but it also talks about other things. And you have it there for your review, this February 14th, 2007 email. And one of the things that it doesn't talk about is the package that she supposedly received in the mail that day. Take a look at the time. It's around 4:30, 5 o'clock in the afternoon. I guess they have mail that's really slow there in Palm Desert. Never mentions these unholy underwear, these underwear, these Spider-Man underwears that so shocked her. Doesn't mention these chocolates. Thank you for sending those to me. Doesn't thank him at all. The reason she doesn't thank him and the reason that she doesn't mention it is because there was no such delivery. But of course, that's something that can't be verified except that there's this inconsistency. And it starts showing that this individual will make things up. But she forgot. She forgot about that February 14, 2007 email. And you know, sort of the old saying with the truth, you ain't got to remember nothing. At least you have to give her credit for having an incredible memory. Well, an incredible memory as to the fantasy world that she wants to create for you. Just like that delivery of the underwear. Can't show them to us. Why? Oh, she threw them away. But she took pictures of some other things. And this email was sent out at a time where she would have already received the mail. But after that, she and Mr. Alexander continue on. And she comes over later on that in the month of February. And when she comes over in February, one of the things that happens is that she's extremely happy, or at least that's what she tells you. And she's happy because one of the things that she now knows is that, well, she and Mr. Alexander are together. If she is so happy, if she is somebody that really wants to be accepting, then why, I tell, does she need to go into his computer and hit that backspace
Creations by
That's
Melanie
such a
and Emily Looney.
Oh, such an irritation
Welcome
to
back.
her that these computers should have this backspace button.
But also, I think I have almost
that she
gifted
can't keep
memberships,
her hands off of this
and I want to thank
computer.
you for
It's
that
really
too.
his fault, and it's
I was
really his
chatting.
fault because he's
I
alive.
was talking. You guys
He's a
didn't think I was
breathing
talking, but I was
human
talking.
being who has social contact with
Jen, thank
other
you so
people,
much for the
men
super
and
chat.
women.
Sam,
And
I
how
think
dare he
also
when they
sent a
are
super
not
chat. If I saw it right,
exclusive?
thank you
How
for that.
dare he attempt to spend
missed you, I'm
New Year's
sorry.
Eve with somebody? He
I
should
was
really
talking,
be
and
alone
nobody
in
could
his
hear me.
house or in some hut somewhere alone. How dare he do that? But it's not her fault that she found that out. At least that's what she wants you to believe. Well, they continue this dating, and they continue both involved in this prepaid legal. But the story doesn't get any better. What we're able to glean or find out from the history of it is that it doesn't get any better. And one of the things that starts to happen, according to her, is that she starts feeling something. Of course, her feelings are so important.
Could it be?
And rather than talk to Mr. Alexander, rather than say, oh, I have these issues, I'm a little concerned, what does she do? Well, they're on vacation. And when they're on vacation, and it depends on the story that she tells, the one to Ryan Burns or the story that she told you from the witness stand, take your pick, because there are many to pick from. But it depends on the story that you believe. During that time, she goes on and she gets a hold of his text messages and goes through all of them, ostensibly while he's either asleep or taking a shower, take your pick. And while he's doing that, she goes through it and finds some text messages. But it's not her fault. She's not wrong in invading his privacy at all. How could she possibly be wrong about invading his privacy when she had feelings? And those feelings confirm the fact that he was a social human being. That's what in part that she liked about him, that he was very charismatic, that he was very nice, and that people liked him. That's part of the reason why she liked him, but oh no, not when it comes to other people. And she talked about him having sexual rendezvous with these other people. But that's quick, if you will, on the slime and very slow on the facts, very low on the facts. You don't have any individual.
507 away from
They can
10K.
point to a name.
Objection, Your Honor, burden shifting.
507 away.
There was no name that it was even pointed out that he even had any sexual contact with at that time. But she felt it, so according to her, that justified it. This person with this borderline personality disorder. And so as a result of that, she
1.7%
said, that's
of the
it.
subs
We're going to break up.
of RA.
And we're done with this. Except that
So I
I'm
just need
so
that.
hurt. I'm so absolutely hurt, she says. You could almost feel it oozing through those fake tears that were supposedly coming from her, from the witness stand. You could almost feel this. And what you could feel, of course, was Yeah, I'm really hurt, except let's go on vacation. Let's go ahead and go on vacation anyway. Even though I know all about this, I'm so hurt that I would rather go on vacation with you and enjoy it. And let's continue going on vacation. Yeah, that's her way of manipulating him. That's a way of not letting go of something that she wants. She wants to curb his free will, and what he doesn't want to do that, well, she's got something else coming for him. She is not going to let him get away that easily. And so she starts engaging in this conduct. So what else does she do? She does what every person who has caught their boyfriend, according to her, being unfaithful, what does she do?
Just because I
She moves
forget it.
close to him, moves from California to Arizona, specifically to Mesa, very close to him after they have broken up in the end of June of
10,138
2007.
downloads.
That's what she does. Well, now this is when the stalking begins. Well, maybe it was a little
We
bit
had
before that when she's going into
864
his telephone. Or maybe it was
yesterday
before that
alone.
on the first day that they decided to make this official when she started to go into his computer. There it is. It is clear
For a
from
pod
this
with only
relationship
23
that
episodes,
there was
that's
the
pretty damn
stalking
good.
behavior from the very beginning. And
In the
so
last month, we've had
she moves here to Mesa.
4,800 downloads.
If they are not dating, if they are haven't broken up, why is she here? It's not her fault, don't you know? It's not her fault because he's so persuasive. He talked her into coming out here. That's why she came out to Mesa. And it's this thing that she just can't say no. Just like with whether or not they're going to engage in this sexual conduct. Can't say no. And in this particular case, according to her, and Mr. Alexander's not here to maybe dispute this, according to her, she moved here because he was the one that told her to do that. Even though, according to her, at this point, she had broken up with him. And what does she do when she comes out here? Well, rather than dating, rather than becoming involved in some sort of social scene in the Mormon church or finding friends and that sort of thing, no. That's something else. She begins to be more attentive. That's the word. She begins to be more attentive to Mr. Alexander. Perhaps if she's more attentive to Mr. Alexander, perhaps then he'll want to come back and have her be the only one. And the way that she's attentive is the way that everybody does it normally. I mean, she goes over to his house unannounced at night, sometime around in August of 2007, and this is what everybody does. And she goes over there and starts peeping in a window to see what it is that he is doing. And he goes over there, and by the light of the television, if you remember, there was this go around by the light. Well, it may have been the light of a television, but now it's the light of truth that we are looking at things. And what she was doing is she was invading his privacy by coming over and peeping in the window. And that is stalking behavior, irrespective of what Alice LaViolette has to say. This individual, Alice LaViolette, who had problems with the truth when she spoke to you about how many times she had testified on behalf of men. This individual who, quite frankly, misrepresented that to you when she was testifying. But according to Alice LaViolette, that was no big deal because that's what.
Can I tell you all that the average growth rate of a YouTube channel is 1,000 subscribers in 22 months. Brandi and I have been around since April. That's 5 months. 5 months. And we're almost to 10,000.
A person does. She came over and started to look inside, and lo and behold, it's not her fault that she has vision. So she starts looking in there, and lo and behold, there he is. Yes,
Thank
there
you
he
for the
is.
blessing.
He's kissing another woman. Like that is the end of the world. So what? So what that he's kissing another woman? He's not seeing her. He's entitled to do it. And he's entitled to do it. He's in his house. He has the lights off. It's a
I hope
romantic
Brandi's
evening, whether she likes it or
ordered her
not.
clogs.
He's moved on. And yes, she says it's his fault. He shouldn't have been courting me. He shouldn't have been continuing to have sex with me. could have said no. She could have left. She could have moved back to California. She could have never come out here in the first place. She's the person who starts to stalk him. And so she says, oh, I was so upset. And she starts talking about the brassiere, whether it was unhooked or not. And we went around and around about that. So what? Well, don't you know he's a Mormon boy? They're not allowed to do that.
All right.
What does she care? Is she the Mormon?
Not allergic to nuts.
Is that what we have going on here? No, she's not anything like that. But she wants to make it seem like it's his fault. She presented it in a way to manipulate your perception because he's trying to take away from him with lies the only thing that he has left, and that's his reputation. He's not here to talk about it, and so it's an easy shot for her. But at this particular point, she's the person that starts to stalk him. And after she starts stalking him, or after this event of stalking, she doesn't leave it alone. No, she comes over the next day because she's in the right. They've broken up, and it's okay if you're broken up to come over and peep at your ex-boyfriend's house, and then in peeping, find him doing something, and then wanting to get an explanation. What possible explanation could he ever have owed her at that point? Oh, and you know, she didn't write about, that's the first incident of domestic violence. Didn't write about that incident of domestic violence, don't you know? Because, well, she's a nice person. And you know, there's this secret that she's watched, this movie involving The Secret, that talks about the law of attraction. And this law of attraction says that you lie. That's exactly what they want you to believe. Now they're starting to justify the lies. It's okay to lie in the journal, which in a sense is saying lie to yourself, because the law of attraction says it's okay to lie. Absolutely okay to lie. You don't put down exactly what's going on, and so you don't write about this. Actually, what's going on here is that she's making it up, and there's no corroboration of any incident whatsoever. And so this relationship, if you will, if you want to call it that, continues. And there are more exploitive, sexual kinds of things that are presented, and that you are regaled with the most intimate details that you could possibly think of. And every time it was, well, I was uncomfortable, but I didn't want to tell him no. It was just uncomfortable. Wait a minute. But she also sent him text messages. And those text messages indicated that she was not uncomfortable. She's the one, and I don't need to repeat it, you remember those text messages, where she's the one that's requesting the sexual acts. She's the one that's saying to him, if you're good, this is what's going to happen, and then I'm going to want something else. So she's the individual that, if we look at the corroborative, the independent evidence that we have, she's the individual that's in this as much as he is. There's no indication that he was ever forcing her to do anything at all. But you know, she's attempting to manipulate you by saying, well, yeah, I went along, but I really didn't want to. And with regard to these acts of
Good night,
physical
Ricky.
violence, well, they weren't so bad, and I didn't write about them. And with regard to any particular physical act of violence, there's no one that knows about it. There's no one that has seen any bruises. There are no police calls to 911. And she has a reason for that. The reason that she didn't call 911 involving Mr. Alexander is because she had a similar experience with Bobby Juarez. And when she had that similar experience with Bobby Juarez, well, she called 911, and you know what? Those 911 people in California, you can't trust them because they talked to Bobby Juarez, and as a result of talking to Bobby Juarez, well, they didn't come out. And so I was so soured by that circumstance that I just never decided to call 911. She's trying to provide a justification as to why there are no 911 calls. The reason there are no 911 calls is because it never happened. Everything in this case points to the fact that it did not happen. There are no medical reports. There are no friends. There is no one that can come in and say anything about that. There are no medical records. There is absolutely nothing to the contrary. What is it that you have? Well, on the day that in March of 2011, 2008, when she told Mr. Alexander, according to her, that she was leaving, he turned around and he hit her. And according to Alice Laviolette, he slapped her, but the defendant went round and round and said, no, it was the back of the head, the side of the head. It depended apparently on her whim as to where he hit her. But if you take a look at the entry for that particular day in March of 2008, you know, I told him, he was so upset. And he didn't want me to leave because, you know, we were both so in love with each other, is what she writes. And then she says, oh, he kissed me so tenderly 3 times. They were such wonderful, tender kisses. Is that what she means when she is talking to you about domestic violence? Kissing. See, that's the problem. You didn't get it the first time. Kissing is domestic violence. Tender kissing is domestic violence. But then you bring an apologist like Alice Laviolette and you say, you're right. No, that's not what it means. You need to go behind this diary here. Those words don't mean what they say. You need, for example, a little cheat sheet that tells you that under the law of attraction. That's not what it means. Under the law of attraction, it means just the opposite. It means that he did hit her. Can't you read that? What is wrong with you, almost, is the way it's being put to you, that you can't see that you can't buy or can't be manipulated. And the other thing that we have is that she claims that on January 22nd of 2008, there was also this act of domestic violence. It matters not what the act was at this point, because there's no corroboration involving that act of domestic violence either. All we have is a journal entry of January 24th of 2008. And in that journal entry of January 24th of 2008, she writes, you know, as far as January 21st, 22nd, and 23rd, nothing noteworthy happened. Not only do we have the diary relating to that, it says nothing happened. But again, you are being asked to take a leap. You are being asked, such as in the gas can example, to think that everybody else is wrong and she's right. And in that example, the one involving the 24th and the supposed incident of domestic violence on the 22nd, you are being asked to say, no, something noteworthy did happen on the 22nd of January. And the thing that was noteworthy on January 22nd of 2008 was that he beat me. And this is the time that I had my hand up. And this is the time that he came after me. But it doesn't say that. Not only is there not any corroborated evidence that can be presented, it's to the contrary. She herself said that it didn't happen. But she wants you to go back and say, well, don't look at what I wrote. Look at this code, this law of attraction. Take a look at that. Combine that with my words. Combine it with what Alice Laviolette says. We'll add that in there. And once you do that, you will be able to see and you will be able to know that, hey, you know what? He did abuse me.
Stupid is,
Right
stupid
before
does,
she leaves
sir.
in April of 2008, she says that another incident happened. But she doesn't tell anybody about it. She still stays at his home. And off she goes. And what's interesting about these acts of domestic violence is that she was very specific as to 4 of them. But again, you know, with the truth, it's very hard to keep it straight. With the truth, you ain't got to remember nothing. But if you're not telling the truth, if you're trying or attempting to manipulate, you do have a lot to remember. She forgot that there is a psychologist by the name of Cheryl Karp that has previously been involved in this case and had conducted an evaluation of the defendant. And during that evaluation with the defendant, she gave many, not 4, many, 10, 15, 20 incidents of physical violence. Because at that point, physical violence was being used as the predicate, if you will, the seminal act for post-traumatic stress disorder. That's what she was looking at that time. And so, of course, let's have a lot of acts of domestic violence.
In fact, it's not an evidence.
Overruled. The jury is directed to recall the evidence presented during the trial. You may continue.
And so you now have this lots of acts of domestic violence that she doesn't tell you from the witness stand compared to 4 that she does tell you. Which one is true? The only evidence that you have indicates that none of it is true because she can't keep it straight. And she's attempting to manipulate the evidence to fit the goal that she has at that particular time. With regard to Cheryl Karp at that time, according to Janine DeMarte, one of the things that was going on is that Cheryl Karp found that post-traumatic stress disorder of the defendant involved these acts of domestic violence, these many acts of domestic violence, not just 4. And so now when they want to talk about this in a different vein or a little bit differently, it's not just all these acts, it's only 4. And that's the problem with the presentation and her attempt to manipulate you.
Oh my.
It's actually not even an attempt to manipulate you. They're lies. That's what they are. And she forgot, perhaps, about speaking to other people and the statements that she made with regard to that. Well, she does move away. And when she does move away, it's almost, if we're talking about light, almost like a ray of sunshine for Mr. Alexander. One can only imagine that his stalker is now far away because she had done other things while she was here. One of the things that we know is that she would come over unannounced. One of the other things that she would do is she would get into his accounts. And there's also this incident involving Christmas and being underneath the Christmas tree. There's all these incidents.
Ultimate shade
Mr. Alexander
of it
and
all.
let his guard down at this particular point because he really doesn't have to deal with her on a daily basis. And yes,
Finish
there is
her.
some contact between them on May 10th of 2008. And this is the infamous phone call that involved sex. And actually that telephone call is very important because you can actually hear how she deals with him, even though he doesn't know, based on everything that's in the recording, that he's being recorded. She says, no, it was being recorded pursuant to his request, don't you know? Really? Why was it being recorded at his request? He's not going to be, can't listen to it. So what possible benefit is this call going to be for him? If he's recorded, if he's not going to get it, there's absolutely no benefit to him on May 10th of 2008 to have that telephone call recorded. Yes, he said some things on it, but this is supposed to be, from his perspective, a private conversation, never to be released to anybody, between him and this woman that even though she's moved to Wairika, even though they've broken up, even though she's come over and watched him with another woman, even though all of this has happened, she stalked him. Even though all of that has happened, he's going to continue talking to her on the telephone. And he says, and he tells you the reason why. And the reason why is that he enjoys having sexual contact with her. And he gives you the reasons why. And he talks about some specific features that he didn't do before and that he does now. He talks about how she introduced him to certain things, how that was such a good thing, kind of opened his horizons with regard to that particular aspect. And so he's giving her credit for opening his eyes sexually. And there's nothing wrong with that. And there's nothing wrong with the conversation. What is wrong, or what appears to be wrong, is that one of them is recording it without the knowledge of the other.
Objection, facts not available.
And here we go.
Sustained.
You'll be able to listen. You've listened to that recording. You can draw your own conclusions as to whether or not you believe he knew or believed that this is something that was being recorded. She says, oh no, I kept hitting the save button. I was the one that did it. And she kept it. And she kept it all the way from May 10th of 2008. But things were not going so well at that point. And in fact, by May 19th of 2008, just 9 days after that, Mr. Alexander is on the computer, this instant messaging service, with somebody named Reagan Housley. And he's talking to her and he says, I'm extremely afraid of Miss Arias because of her stalking behavior. How prophetic of him, back on May 19th. And this is 9 days after this telephone call. But He's extremely afraid of her.
What's happening here? Is it just me? Like, I don't want to make fun of somebody's appearance, but actually it's very different than the rest of the 100 billion days that happened. Just a bad part? Is that what's going on? Who knows more than me about hair?
Because of this stalking behavior. Little does he know that he has less than a month to live. And so he is aware of it. He knows that he's in the best position to know what is going on between the two of them because he's the one that's going through it. And so when he makes that comment is indicative of what is going on. You can have people like Alice Laviolette say, it's not true. And the reason, we have to give her credit, is that the reason Alice Laviolette knows that is that she can read minds through the past. She can travel back to May 19th of 2008 and know what Mr. Alexander was thinking, don't you know? She's the apologist or the defendant. She's the one that can really set you straight. It's not the defendant that's manipulating you. No. If you take a look at that statement, Mr. Alexander was making it all up. Wasn't true. He was just saying it. Because, in another part of the instant messaging, they were saying, hi, Jodi, read this, or words, whatever it is that they were saying. And so, the defendant doesn't want you to pay any attention to that. But that certainly goes, and it's the beginnings of premeditation. Her premeditation to kill him back on May 19th of 2008. He indicates that. I am extremely afraid of the defendant because of her stalking behavior. And who would know better than him? Especially since he's the one that's had to deal with her coming over, peeping in his window. He's the one that's had to deal with her showing up unannounced. He's the one that's had problems or damage to his car, according to Lisa Andrews. And he's the one that has her underneath the Christmas tree and has had rings stolen by her. So he would know that. And so then what ends up happening is that some time passes. And May 26th shows up. One of the important things about May 26th is that is the day that they break up. And there's much is made by the defense that, well, during these conversations, he's mean to her. Well, why wouldn't he be mean to her? Yes, there are names that people are being called. That's correct. There are not any nice names. But he is extremely afraid of her stalking behavior on May 26th when those names are called. And there is anger that is being exchanged back and forth, and he sort of capsulizes it by saying or using a term that's not quite so sexual.
Thank you,
really
Amy.
Capsulizes what's going on here and how the defendant
True
attempts
crime
to manipulate
addict. Welcome.
the truth. When he says, I am nothing more than a dildo with a heartbeat to you. That's what he tells her. Because that's how he feels. That's how she makes him feel. And yes, he uses all of those other words, but he's also very derogatory about himself. He knows what's going on. Every time that, according to that statement, whenever she wants him, the way that she manipulates him is through sex. That's made that comment. So, and that comment was on the 26th of May in that instant message. But you don't ignore what else is going on the 26th of May of 2008. On that prophetic day, he also tells her something else in Exhibit 450. She's apologizing to him. Again, she's manipulating him. She does something, and she apologizes, and everything is supposed to be okay. But by this time, he has had enough. And he says, I don't want your apology. I want you to understand what I think of you. That's what he's telling her. He's telling her he wants her to understand what it is that he thinks of her. He says, I want you to understand how evil I think you are. At that point, when he's writing that, he is extremely afraid of her because of her stalking behavior. And he does think she's evil. And how prophetic Look at it, these next words, how absolutely prophetic. No one can dispute that that is the truest, those are the truest words that are spoken in this case. And they're spoken by Mr. Alexander, even though he is not here, through his writings. You, Jodi Arias, are the worst thing that ever happened to me. Any doubt that that's the truth? Do we need to look at the pictures of his gashed throat? Do we need to look at the sort of frog-like state that she left him in, all crumbled up in that shower? Or do we need to look at his face where she put that bullet in his right temple to know that what he says there is true? You are the worst thing that ever happened to me. He's telling her enough is enough. And yes, he's angry, absolutely angry, after everything that she has done to him. And you've seen the manipulation as she has tried to manipulate you with what she has told you. And the prime example is these gas cans. No one can argue that she lied to you. Well, he's had enough. And yes, he says you are the worst thing that ever happened to me. And then he says, in this exhibit 450,
Trash talk.
you are a sociopath. No, he does not have a psychology degree. But that certainly expresses a feeling about what she says, what she does, and how she deals with him, how she always is manipulating him. It teases this anger out of him and tries to mix in the sex, and he says, you only cry for yourself. Well, you saw her crying on the witness stand, and anybody debate the reason she was crying is because she cries for herself. After all, she never intended to be caught. She said that so herself after she lied to the police. Oh no, I was saying it because I did not want to be caught. And so you only cry for yourself. And then he says, you have never cared out me, supposedly that could be 4, and you have betrayed me worse than any example I could conjure. She has betrayed him. For whatever reason, he believes that she has done something that is absolutely horrific. And he's telling her, I've had it. I'm done with you. And again, this is May 26th. He's done with her. You are sick, and you have scammed me.
And boom goes the dynamite.
Again, she has scammed him. Are you going to allow her to scam you? Is really the question from this text message. Are you going to buy her lies? Are you going to believe what she tells you? And so we get to May 28th, just 2 days afterwards. Just 2 short days afterwards, he begins to plan, if you will, this killing. And planning takes preparation. And there's no doubt that this woman is a very intelligent woman. And she tries to cover all of her bases. And yes, she could go out and buy a gun. But you know, if you buy a gun, one of the things that she indicated in California was that there was a waiting period and they take your name. According to her, that's something that she knows. Well, let's get a stolen gun. She lives with her grandparents in Wairika, and she knows that they have that her grandfather has guns, and she knows where he keeps them. So on May 28th of 2008, she starts the planning. She starts the actual steps, or begins the actual steps to this journey that will take her to Mesa, Arizona to kill Travis Alexander.
Game over, man. Game over.
There is no other explanation than that she's the one that stole that 25 caliber gun. This very small gun that, according to her, looks like a toy. This small gun. And on May 28th, at a time when she's living there, there's a burglary that is reported at her grandparents' house. And lo and behold, it's so amazing. And again, this is the manipulative aspect of this case and the defendant. It is so interesting that this burglary of the house is kind of weird. It's kind of strange. It's kind of special because these burglars were meticulous. They wanted to leave the impression that this was a burglary throughout the house. So they went through 4 rooms. And from each of the rooms, only one item was taken. And where the guns were, you saw there was some money there. These burglars didn't want money. They just wanted the gun. And they didn't want any kind of gun. They wanted a special gun, a small gun, because there were rifles there. If a burglar comes in, he's not going to be very discriminating. I'm going to take this little gun. I don't want to take the money, maybe too heavy. These other guns are too big. I'm not going to be able to carry them down the street. That's not the way a burglary happens. And after I've taken one item from here, I'm going to go ahead and go to another room. And after looking in this other room, I'm going to take one item from there. And then I'll take a total of 4 items. If you're going to do that, if you are a burglar, then why? Why even waste the time of committing a burglary? The only thing that makes sense with regard to the burglary is that the burglar, the person who went in there, it's right there. It's Jodi Arias. That's the burglar. And she needs a gun. And she needs a gun to kill Travis Alexander. And she gets it. Guess what? Can't be traced. There's this burglary report out there. No one can say it's her. Well, at least not initially. No one can say it's her. But on May 28th, she begins to take these steps after he has told her in that May 26, 2008 text message that he'd had enough of her. And so what does she do as part of that? Well, she then says, but if I go to Arizona, money is tight. There's an issue with money. One of the things I'm probably going to have to use is my credit card. If I go to Arizona, if I fill up with gas. So I've got to make sure that people don't know if I'm going to carry this out that I'm going to be in Arizona, because I can't be linked to Arizona in any way, shape, or form. And certainly using a credit card at a gas station is going to link me to Arizona. And so, well, why don't I call Daryl Brewer? You could tell from the time that he testified that he still had feelings for her. In fact, when he was asked about this issue about the gas can, he actually paused, if you remember, and he gulped and he said, oh yeah, she did call me. She called me at the end of May. May 28th is the end of May when this gun is stolen by the defendant from her grandparents' home. Yeah, she did call me then, and she told me she was going to Mesa. She was going to Arizona. And Alice Laviolette has the same thing in her notes, that according to Daryl Brewer, the defendant called him at the end of May that she was going to Mesa, Arizona, and needed gas cans. And Alice Laviolette, even in her notes, indicated, I thought that this was an unplanned visit. Even in her notes, there are issues. But the defendant's attempting to manipulate the truth. But there are issues with regard to this because she's telling Daryl Brewer that she's going there. Even her own expert says, there's a little bit of an issue here. There's a problem for me because I thought you said that you were not going to Mesa, that you were going to Utah. Or is Utah just not anything else other than more than a ruse? You can say you're going to Utah. You can have a sexual dalliance, not an extreme one, but a sexual dalliance with Ryan Burns. You can adjust him, and nobody will be the wiser. Because nobody will ever know that you were in Arizona, because guess what? You never filled up anyway. You never put gas in the car. Well, okay, that's what she does. She calls Daryl Brewer the end of May, first part of June, and she gets these 2 containers, 2 5-gallon cans for gasoline, and they were empty. So it wasn't like they were full. And he lives in the Monterey area, and she leaves on June 2nd. Well, when she leaves, she doesn't take her own car. She decides to rent a car. And she has told you, well, I rented the car out of Redding, California. And the reason that I rented the car out of Redding, California, which is approximately 90 miles south of Wairika, is because Priceline did not offer this same deal in Wairika. Priceline only offered it in Redding.
All right, everybody. If you were able to stare at my face, you could see that I am struggle bussing. Today has been something else. All right. Well, I would say successful night. On Friday, we will continue. On Friday, we'll continue the majority decision for Joel Guy Jr. Brandi is slated for the Hollywood sex therapist murder trial day 4 tomorrow at 8:45 Eastern. So definitely tune in for that. If you missed today's interview with Dr. G, you can check that out on our channel. You can head over to Corroborating Consciousness. That's my channel that I'm rebranding. Slowly we'll be adding stuff, and by that I mean really slowly adding stuff, but feel free to hit subscribe. It would be nice to eventually be able to go live by mobile, so that as I have thoughts, I can just turn it on and go. But that being said, thank you very, very much for hanging in there. Thanks for all you do. The amount of success the 13th juror has seen is due to you. So I will say, before I forget, court adjourned. I will also say, take care of yourself. Take care of your friends and family. Don't forget to smile. As Pantoufle says, don't let anybody dull your sparkle. And shine on. Shine on, you crazy diamonds. You all have a good night. I will see you Friday with a brand new trivia. Cult.